let's go back when we're talking about this whole concept of litigation, all right, and concurring opinions, and that's where a lot of the cases come out of. They come out of litigation and litigation areas. Let me ask you just from a couple of questions, because I'm tired of talking and tired of explaining and going through that chart. What are the advantages to litigation? I mean, we're going to talk about in a few minutes. We'll talk about arbitration and mediation. What are the advantages to litigation? Or what are the disadvantages to litigation?
I know, like, with the litigation, like, whatever the ruling is, the judgment is, it's actually upheld, whereas, like, arbitration, isn't that true? Where, like, it's not necessarily, like, by law that they have to pay you or do whatever that the judgment was?
Yeah, I mean, the effect, Whitney, you make some good points. Litigation, you're not really controlling your own destiny. Whereas in mediation, you and I get into a dispute, and we sit down and we mediate it. We may not be happy with the outcome. You may not like everything, I may not like everything, but we know for certain at the end of the day what's going to happen, okay? In litigation, you don't have a clue, and, you don't have any idea what's going to happen. So you've got a little less control with litigation, and mediation can be a little better than that. What else? What are some other issues, advantages, problems, disadvantages to litigation? Jackie?
An advantage of litigation is that it can send a message as far as like setting a precedent. A disadvantage is that it's very costly and time consuming.
Yeah. Litigation can be extremely costly and extremely time consuming. All right? We spend tons of money on litigation. All right? Yeah, Melissa.
Litigation helps change. It kind of helps, if you don't have litigation, the laws aren't going to change and they're not going to move forward.
That's a good point. What Melissa says is that litigation actually, and we don't often think of it as a positive thing, but that is a good reason for litigation. And what she says is that litigation helps change. The reason that litigation helps change is real litigation, if carried out far enough, creates what we call precedential value. All right? And it gets out to the public. Somebody asked me, well, are there less things that aren't so public like litigation? Most of your arbitrations are not going to be in the public's eyes. Most mediations, almost all mediations, never get to the public. And in fact, in a mediation, you frequently sign what is called a confidentiality agreement that says, hey, if Anna and I are in a dispute and we mediate it, there is probably an agreement that says we won't talk about it. Okay? Not always, but frequently there is an agreement to that. So mediation is frequently confidential. Whereas litigation, you can actually get things changed by litigation. Can you think of any particular situations right off the bat?
Well, just ADA, the Family Medical Leave Act, any of those, the civil rights.
Okay.
None of those would have changed if it wouldn't have went to litigation.
Okay. Yeah, we see certain things that change as a result of litigation. And sometimes a particular result in litigation can have the opposite effect. I mean, it can still have change, but we can see a case and we may go, the outcome of that case is so ridiculous, now we need a law to address that. All right? So sometimes it works both ways. But absolutely, litigation can be a public change. We'll go back to the high school situation. As a practical matter, when it was all said and done, it was probably principle for this particular student, and there was a victory and a moral victory. But in terms of the big picture, the district just changed their policy so that it was the opposite of what it was. But the effect was still the same. Now, instead of having a policy that says grades won't be used as a punishment, they just wipe that out, and now they use grades as a punishment. All right? I disagree fundamentally with that idea. But from a practical standpoint, litigation we were hoping would change. That was one of the reasons we litigated it. And it changed it, but not in the way we wanted it. So, yeah, litigation. What else? Anything else about litigation? Jackie.
Well, with your high school example, the disagreement was the wrong felt so flagrant that you couldn't necessarily have come to some sort of you got what you wanted without having to sacrifice, her grades or anything else like that.
Yeah, I think what Jackie says is in our particular example, there was no way to really come to a particular agreement. Sometimes things have to be litigated because there is no way to mediate it. You cannot reach a simple resolution. I mean, if I insist, and I think I'm absolutely right to insist on receiving $50,000 and somebody insists on not paying dime, can you mediate that? Sure. But if I'm so solid that I have to have 50 and I'm so solid, or this person's so solid that they have to have 0, you can't mediate that. Now, that's probably a poor example because you can come to a conclusion. Whereas in the grade situation, it's either all or nothing. You're either going to get your credit back on your grades or you're not going to get there is no happy medium in that. And really what we eventually said, we did try to mediate that case, and what we said is, look, we're not happy with the going from the 30 days to the 180, but if you'll just give us our grades back, we'll even agree to the 180-day suspension, which we think is ridiculous, but we'll agree that we can't participate in cheerleading or golf or swimming or volleyball or any of the other activities that she did, okay? So we tried to mediate that one, or tried to settle that one, but it didn't work. Any other thoughts on litigation versus arbitration or mediation, why you may want a day?
I think litigation, you can have access to a jury trial.
Absolutely. Litigation, you have access to a jury trial, all right? Now, and a very good point, why might people want access to a jury?
To establish a benchmark.
Okay, to establish a benchmark. Why else? All right, listen.
A jury might be more sympathetic with you and side with you versus just a judge or another lawyer.
Right. When I was in private practice, I probably did more employee stuff and plaintiff stuff than I did for the company, okay, or than I did for a company, than I did for the defense, although I did some defense work. If I had a good plaintiff's case, I wanted a jury, all right, because in my opinion, a jury is going to be more sympathetic, all right, and award, and I always said I wasn't out for sympathy, right, but a jury was going to be more, I could get that emotional connection to a jury as a plaintiff than I could with a judge, all right? And sometimes that's the case. And what happens is you also get juries that if they really get mad, will give a lot more money. Dave.
Just thought, wouldn't that lengthen the case and cost
It's a
more
great
time and money and everything else?
It's a great point. Yes, it absolutely does lengthen the case because in front of a judge, I don't have to worry about every single word I say. Yeah, I have to worry about it to some extent, but I don't have to make that emotional appeal and that emotional connection to a judge that I have to make to a jury. And so it's much more expensive with a jury because basically with a jury, and I don't mean this in any disrespect, I love our jury system and I think it's the best in the world, although it does have flaws. I'm putting on a dog and pony show for a jury that I may not put on for a judge. And you're absolutely right. In order to do that, it's a lot more expensive and a lot more time consuming. It takes a lot more investigation, okay? Other reasons, all right? So that's kind of litigation. Now, I don't want to spend a lot of time on it, but just real briefly so that you're not confused when I come back later and you go, what? Didn't you say this earlier? Employment lawsuits, for the most part, do not start out with a complaint. All right? We won't try to get too technical. We've used Jackie's wrongful termination, and that could start out with a complaint. But if Jackie had a discrimination lawsuit, that would start out with a charge, would have to go through an administrative agency, and then eventually you could get the complaint. I don't want to spend a lot more time on it tonight because we'll spend a great deal of time on it when we get into discrimination. But generally, let's go back to Kyle and I. Kyle and I are in an automobile accident. Kyle can sue me the second he can hobble to the courthouse. Okay? But if Kyle has a discrimination complaint against me, he's got to go through an administrative process which takes time before he can file his lawsuit. He can file it, but it'll be dismissed, okay? And we'll spend a lot more time on that when we get into discrimination, but the employment situation, if it's discrimination, is a little bit different. You just don't rush out to the courthouse. All right. So we've got litigation as one way of handling our disputes, if you will. What other forms do we have besides litigation to handle our disputes?
Arbitration?
Yeah, Amanda, we got arbitration. All right. Tell me, and probably this is where we had a lot of areas of questions and a lot of areas of concern. So not spend a great deal of time on it, but tell me a little bit about arbitration. What do you think arbitration is, or what have you picked up on arbitration, Amanda?
It's in front of a judge,
Okay.
and either the decision can be binding or non-binding.
Okay. And let's kind of stop there. With regard to arbitration, it is in front of, and I'm going to pick on you just a little bit, it's in front of an arbitrator, okay? Because generally, your arbitrator will not be a judge, will not be a current judge, all right? Will not be a current judge. And the reason for that is your current judges are sitting on the bench handling litigation, okay? Now, having tweaked that a little bit, an arbitrator acts exactly as a judge. So you're absolutely right. When you say an arbitrator is a judge, you're absolutely right, because the arbitrator acts as a judge, but technically they are not a judge. Frequently, your arbitrators can be people who do only arbitration, all right? They can be retired judges, all right? They can also be lawyers that are specialized in a particular field. Had a case going when I left private practice that is still going and will go for some time. That was a construction case. That construction case, the arbitrator is a lawyer who spent a large part of his practice handling construction matters, okay? So he is well versed in construction law, and all of us got together and decided who we were going to pick as an arbitrator. And how do you pick an arbitrator? Well, there's lots of ways. If you can come to an agreement and pick one, great, all right? We have a judge here, former judge here in Springfield, who is well respected and well liked. He does some arbitration, and frequently parties will get together and say, hey, let's just give this to this former judge over here and let him be the arbitrator, all right? That's great in a perfect world. But generally, when you have two sides that disagree, they'll even disagree as to who the arbitrator is going to be, all right? And so frequently what happens is there is a policy of where the plaintiff will pick one arbitrator, the defendant will pick another arbitrator, and the two arbitrators will pick the third arbitrator, okay? So you've got this idea of a neutral arbitrator. Somebody asked me how are arbitrators picked, okay? And that's frequently how they're done. If the parties can't agree, they'll pick one, they'll pick two, then the two arbitrators will pick the third. Sometimes what happens is you are given a list, all right? And in fact, in this construction case we had when I was leaving private practice, that's exactly what happened. We had a list of all the arbitrators. So there are like 10 names, if you will, given to us. We got together and we said we want a lawyer who has construction background who has done this. We were given, I say 10 names, that's probably an exaggeration. We were probably given 5 names, may have even been given 3 names. Then what happened is each side, without the other side knowing about it, went through and struck a certain name. We said, absolutely don't want this one. And they said, we absolutely don't want this one. And it turned out that we had one left that we all agreed to. And we didn't know we were agreeing to that one, but that's how. So that's how arbitrators can be picked. You can either pick them by agreement, you can have 3 arbitrators and the 2 pick them, or you can just have a process of elimination that is kind of overseen by the American Arbitration Association or something. Somebody asked, how does arbitration work in the employee field? Well, just because we've used so much of the Jackie-Randy situation, we've talked about that in terms of court or litigation. But Randy and Jackie could have said, hey, let's just take this to an arbitrator and let this third person decide. Okay? What are some of the advantages to arbitration? Okay, cost is supposed to be one advantage, and it is, and everybody says that cost is an advantage. I will tell you that in what I've seen, cost is not necessarily an advantage. And I think the American Arbitration Association is a great situation, but I'll give you this construction case. It was filed. You know what a filing? Anybody want to pick on you, Jackie? What's a filing fee? Do you know? I mean, you know what a filing fee is.
Yeah, I know what it is.
How much does it cost to file a lawsuit in court? The best guess.
I feel like it's like 35 or 50.
All right. Okay. Yeah. In associate circuit court, you can file, and we'll use Greene County. All right. Associate circuit court. Those are cases that are basically under $25,000. All right. Anna owes me $50, or let's get more than that, Anna. How about let's reverse this, okay? I owe you $5,000. All right, we had a contract, I didn't fulfill it, so I owe Anna $5,000. I say I'm not going to pay you, so she takes me to court. She can file in Associate Circuit Court here in Greene County and pay a filing fee of $35, and it may cost another $35, $40 to actually find me and get me served to haul me into court. But for $100, Anna can bring me to court, all right? On a much bigger scale, well, let's say that, oh my, Kyle has been hurt so bad when I ran over him, okay, with my FedEx truck. And he's got $1 million of damages, all right? He can go to circuit court and basically pay $250 to $300 to get that case into court. Here's why I say arbitration is not necessarily cheaper. The attorney who had the arbitration case, or this construction case before I did, had filed it in circuit court. He was going to litigate it. And what happened was the other side says, no, we had a contract, and we'll talk about binding, non-binding in just a minute, but we had a contract that says you have to use arbitration. So then he filed with the American Arbitration Association. And he filed the claim as a claim under $10,000, all right? It may have cost him $500 to file that claim under $10,000. And the reason he used under $10,000 was because the filing fee was so cheap. I filed got into the case, looked at it, damages, building was about to fall down. Damages were a lot worse than that. And I filed and amended the claim for $600,000. I mean, we're talking, and actually almost $700,000. We're talking, in my opinion, poor construction project. Guess what the filing fee was? I mean, somebody guess. Melissa.
$1,000.
Okay, keep going. We got $1,000, huh? Darla?
$2,500.
Keep going, $2,500. $6,000, all right, to file that before the American Arbitration Association. Now, I'm going to have to do a lot of discovery, a lot of depositions before I catch up to that $6,000. So, from that standpoint, it's not always cheaper. Now, if you go back to what Day says, where you have a jury trial, yeah, it's going to be a lot cheaper. I don't have to put on the same dog and pony show, and the discovery and a lot of things of that nature are going to be cheaper. But it is not always cheaper for arbitration. Certainly can be, okay? And again, I don't have to impress the arbitrator like I might have to impress a jury, all right? I don't have to explain, particularly if I have somebody who has construction knowledge, I don't have to educate him the way I would educate a jury. Amanda.
What are the benefits of companies putting arbitration clauses in contracts or documents?
Okay. And Amanda asks a very good question. What are the benefits from putting arbitration clauses in contracts? Okay? For an employee situation, right? Yeah, for the employee in handbooks or making them sign, and that happens all the time, all right? What is the benefit of that? Why do employers, here I am on one hand saying it's going to cost a lot, and by the way, that it's that initial cost, which is a lot. But what is the advantage for employers to put that into their handbooks? Whitney?
Well, one thing is with litigation, it's public, and so people are gonna find out about it, so by putting an arbitration clause, if you have a dispute with an employee, it's gonna be more private, and not everybody's gonna know.
Very good. Because what happens as an employer, and what happens to an employer when it gets out that they have discriminated against somebody? What happens to that employer?
I mean, it's bad publicity, even if it's true or not. It's just yeah.
Okay, bad publicity. Darla says ruins your reputation. What else? More lawsuits. More lawsuits. Okay? And I'll share the story of one time why we tried a lawsuit just to keep the attorney from coming back when we get into the discrimination standpoint. But yeah, more lawsuits. Jonathan?
That's what I was
Okay. All right. Why else?
Less profit.
What do you mean less profit, Tom?
Because of the bad reputation, you'll lose sales.
Okay, you don't want to lose sales. All right, so everything that goes hand in hand with this bad publicity. Why else may I want it to be arbitration as opposed to litigation? What did I just tell you about the reason I want a case in front of a jury? Why do I want a case in front of a jury? The emotional, the emotional, the feelings, all right? And if I'm an employer, all right, and I go to an arbitrator, suddenly the firing of the 64-year-old woman is not nearly as emotional and heart-tugging or tugging on your sleeves to an arbitrator as it is to a jury. Why? They see it every day. That's not to say they get cold to it. That's not to say that there aren't arbitrators who will give as big a verdicts as juries in the right situation. But more than not, you don't have the problem with a runaway jury. Okay? What else? Any other reasons? Let's go back to kind of this binding arbitration, non-binding. Somebody asked, well, how do you decide if it's binding or non-binding if you don't have a contract? It won't be binding, okay? Unless you have an agreement of some kind, you don't even have to do arbitration, all right? So unless you have an agreement of some kind, you don't have to do arbitration. And then I think somebody had asked, what's in the arbitration a way of taking advantage of the employee? Yeah, it is. Yeah, it is. And we'll talk about the employee at will. The thought is, well, the employee doesn't have to sign, all right? If you get a job and you go to that job and you're ready to start that job and they hand you a document that says, sign this, you'll agree to arbitration, and you say no, what happens? You don't have a job. You're not going to get the job, okay? Now, the courts are looking at those arbitration clauses a little closer, and they're scrutinizing them a little bit more and saying, hey, this isn't really isn't fair, okay? But, they will enforce them, okay? Any other questions with regard to arbitration? Somebody asked, and it was a question I think I saw frequently, is why would you ever agree to non-binding arbitration? And it really is a great question. I don't know why, okay? And I will tell you that in the real world, while there is such a thing as non-binding arbitration, in the real world it doesn't exist because you're not going to go through arbitration and not have it binding. Otherwise it's called mediation, which is where, and really the advantage, and your book, I don't want to talk about your text necessarily, but what is mediation? Let's do it that way. What's mediation? We know what litigation is, right? And we know what arbitration is. How does mediation differ from arbitration? John?
Yeah, it's like she said, it's non-binding and it's meant to find some type of compromise between the two parties.
Yeah, it's really to find some kind of compromise between the two parties, okay? And it's for the most part non-binding. There are some forms, your book talked about some type, shadow mediation, where you can kind of combine the two and you really have an arbitration, but you try to mediate it before. There's transformative mediation, and you might be familiar with those particular terms. Transformative mediation, just for lack of, in a nutshell, is you're looking at the relationship, and it's let's all hold hands and sing songs together and say how wonderful we are, and we want to preserve the relationship. You know, the bottom line, whether it's transformative mediation or evaluative mediation, let's talk about that term. Evaluative mediation is where the mediator won't make the decision for you, but will suggest, here's what you need to do. Okay? Here's what you need to, here's what I would recommend. And that's a good, you see that in a lot of cases, because you see people who say, hey, my case is worth $6 million, and you see somebody else says no, and the expert says, no, it's not. And let's get you into the real world. Okay? And sometimes a mediator can help. Any question? I don't want to spend a lot of time on the mediation aspect of the arbitration. Litigation is exactly what it is. It's the court system. You've got arbitration, which is this whole idea of basically having one arbitrator make the decision, and you got mediation, which is where you're trying to come together for a resolution. And if you do, great, and if you don't, okay, then you go on to either arbitration or litigation. Any questions on that? All right. That's all we'll do in this class period. Next one, we'll talk about independent contractors, and we'll go from there.